He has two attorneys.
Okay. This is the Juneau courtroom. Who just joined the line?
This is Hannah Siebold with the DA's office. I am just observing today.
Okay. This is the Juneau courtroom. Who just joined the line?
Attorney Robin Schmid for Geoffrey Alter.
Thank you. Ms. Wolfstead, do you know what other attorney is supposed to be calling in?
I would expect Mr. Pulaski, as he represents him on the other case.
Okay.
Yes, he will be calling in, and Geoffrey Alter's mom, Jean, will be calling in as well.
Okay, thank you. This is the Juneau courtroom. Who just joined the line?
Jean Ann Alter.
Thank you.
I just emailed Nick. I don't have a cell phone number or anything for him, but
I emailed him.
okay, we had been conversing, so he knew it was going to happen. He might be in another case.
This is the Juneau courtroom. Who just joined the line?
Nick, hi. Thanks for emailing me, Beth.
Sure thing.
The only bad thing about everything by phone is you start doing things or you get a phone call and then you forget to call in for court hearings. When you're in the courtroom, that doesn't happen.
It's okay. I know where to find you. All right. Juneau Superior Court is now in session on the
All right, our first case is 1JU18105 and 191567, State of Alaska versus Geoffrey Alter. Mr. Alter is appearing from Lemon Creek. Can you hear me?
Yes, ma'am.
Okay. And on the phone, we should have Miss Kemp, or, well, who is this? Miss Kemp or Miss Wolfstead?
Ms. Wolfstead, Your Honor.
All right. And Miss Schmidt?
Yes.
All right.
And Nick Pulaski.
Oh,
Your Honor, Nick Pulaski is also on the line, and so is my client's mother, Jean Alter.
Okay. Miss Schmidt, do you want to go through what your bail request is?
Yes, Your Honor. Right now, I believe that the bail is set at $10,000. I think it's $5,000 on each of his two cases. Mr. Pulaski represents him in the 2019 case, which was an auto theft, and I represent him on the 2018 case, which was burglary. And my client entered his change of plea on January 28th. I believe he's been incarcerated on his new charge since the beginning of December. And we are asking for a reduction from the $10,000 total to $2,500 cash, and that he be released and monitored by PED on the ankle monitoring. I've called and talked to them, and they said that is definitely something that's still available for him. And also, my client has heart arrhythmia, and I have his mom on the phone in case the court wanted testimony. I don't know if the court is aware or not, but the federal court gave a miscellaneous general order out yesterday signed by Chief United States District Judge Tim Burgess on COVID-19 and requests for bail, talking about medical conditions that might necessitate somebody's early release or release in these different circumstances with COVID-19. So with that, Your Honor, we're asking for a reduction to $2,500. My client be released to the probation electronic device monitoring for ankle monitoring on the basis that he is high risk for COVID-19.
And Ms. Wolfstead?
Your Honor, the state and the victims oppose this request. Mr. Alter has been sort of a profound criminal in the community of Juneau of recent years. and is significantly enmeshed in the drug community here. And Mr. Alter is not in the position that many other defendants are in because he is in a post-plea position. He no longer carries with him the presumption of innocence. He is shown to the court by the fact that while he was on conditions of release for a burglary, where, as the court may recall, $160,000 was stolen, as well as things like vital life-saving equipment for other people, like survival suits off a boat that Mr. Alter specifically stole, that he then committed a new, really blatant vehicle theft where he and his co-defendant stole a truck, spray painted it silver and black. When they were caught with the truck and the spray paint, said to police, "Oh, no, we didn't steal this truck and we didn't spray paint it. We were spray painting a mummy." And he's now in a post-plea position. Lemon Creek and other facilities in Alaska are taking great efforts to protect people who are in their charge. I'll note that certainly we are releasing more people than we normally would, but as far as a risk to the community, Mr. Alter poses a significant risk to the community if he is released, as while he was released last time, he then continued to commit crimes. I'll note, I haven't seen anything from the federal courts, but I'll note that those are not necessarily applicable to the state courts whatsoever. And certainly the victims opposed this, and in fact, specifically the most recent victim, I know her first name is Sarah, let me just pull up her last name, but stated that she didn't necessarily intend on calling into the hearing, but she did want the court to know that she's really concerned that he's going to go out and steal someone's car again, and that he's going to repeat this information or repeat this behavior and opposes his release. So I think overall, Your Honor, this is not a good risk for the court to take, and I would request that the court deny the bail request.
Mr. Pulaski or Ms. Schmidt, do you want to be heard again? I guess I'm wondering, Mr. Alter is scheduled to be sentenced on April 27th. Is he going to be time served on his under the agreement?
Your Honor, he will not be time served. He's also not going to be sentenced on that date because his deal is predicated upon testimony in the Tricano burglary case. I also believe that he was dishonest with the Juneau Police Department during his debrief and may be filing a motion that he not be sentenced under the agreement and, in essence, go back to the drawing board.
Your Honor, this is Nick Pulaski. May I address the court?
Yes, you may.
Okay, thank you. I'm glad Ms. Wolstead added what she did because to me it highlights why a bail request is appropriate. The prosecution is threatening to file a motion to go back on the Rule 11 agreement to have it nixed, which would mean that Mr. Alter would withdraw his pleas and he would go back to pre-plea posture if they were successful in that. I don't know whether they'll be successful or not in that. That's not my case. My case is the attempted vehicle theft, but I think that's a dynamic that's important to note. Another one is that right now what's happening is Mr. Alter is not going to be sentenced until a trial takes place, and the trials, as this court knows, are just being delayed to a point where there's so much unclarity about it that right now what it means is Mr. Alter is in a posture where he's going to be held until a trial that we don't know when it will take place takes place, and then he'll be able to be sentenced. I think that's an important dynamic to note as well. And then the third thing I wanted to say is that just because he's pled, and right now his pleas are in place, they're not, the prosecution is threatening to file a motion to void the plea agreement, and just because, but right now he has pled, but that doesn't mean that a person is not still entitled to bail. And I think that the situation that we have right now is unique enough that it's a case where just because the person is pled, it doesn't mean that nothing else matters, that the prosecution can say, hey, he's pled, so that's the only factor that really matters. And I think there was one more thing I wanted to say. Oh, I think, that regardless of the amount of time Mr. Alter serves or doesn't serve later on, right now there's a unique circumstance going on that suggests that release is appropriate for people. And so regardless of whether Mr. Alter goes back later to serve time under this agreement, or if the prosecution files to get out of the plea agreement and do something different, or whatever happens, the situation that's happening right now is right now, not later on. That's all that I have to say, Your Honor. Thank you.
Your Honor, and I would point out just two things. He wasn't on electronic monitor before. So that would alleviate a lot of the court's concerns. He doesn't have a violent record, so we're looking at property types of things. And then back to the federal order, as I'm sure the court knows, I don't know, maybe you don't, but I would assume you do, that all federal defendants are housed in the state facilities here within the state, and the order that was issued yesterday anticipated pretrial and pre-sentence defendants as well. So with that, again, and with my client's susceptibility, because of his heart arrhythmia, we would ask that the court grant this by balancing the interests of the state and balancing the interests of public health.
Does Mr. Alter have is Mr. Alter presumptive?
Your Honor,
No.
Well, it's an interesting question. He's not presumptive. Well, he would be presumptive on any case moving forward because he's got plea entered to a felony. But he's not.
These are his first felonies.
And was 1JU-19-1567 allegedly committed while he was on release in 18-1058?
Yes, Judge.
So, Mr. Plaster.
And just so the court knows, oh, sorry.
Go ahead.
The agreement called for a sentence of 2 years to serve if the agreement was followed.
Well, I mean, at this point, given that Mr. Alter is post-change of plea, and right now, I understand what Ms. Wolfstead has said is what they're planning on doing, what her belief is, that there might be a motion coming, that the April 27th sentencing might be moved, but right now, that's still in place, and Mr. Alter is looking at approximately 2 years, I think I just heard, under the plea agreement. It doesn't make any sense to me to release Mr. Alter on bail under these circumstances. If, however, the state were to file a motion to withdraw or negate the plea agreement or to move the sentence, I think that a bail hearing at that point would be appropriate. But right now I don't have those things in front of me. I have a sentencing scheduled in 2 weeks that is going to involve jail time. Mr. Alter is charged with multiple B felonies in a case that he then committed another felony, actually not allegedly, for which he has pled, while he was on release. And while I understand that there is the direction that the federal district court is following, this is not a normal bail situation. So right now I'm going to deny it. However, if things change and the state files a motion or the sentencing gets moved, I will reconsider.
Okay, just so we're clear, Your Honor, for a record, you have not addressed Mr. Alter's health risk. Are you not considering that in your decision?
Do you have what proof do you have for me that Mr. Alter suffers from a heart condition?
Well, I have his mom on the phone, and again, I was following the federal order, where if you don't have medical records handy, which we don't, in federal court they were allowing other testimony. And that's why I had his mom. If the court would like to hear, I would proffer that she would be under oath. And
I'm sorry, and I'm cutting you off only because I have another hearing right after. So I would like to go ahead. If you would like to ask Ms. Alter some questions, we're happy to put her under oath and allow you to do that.
All right, thank you. We'll make it quick. I'd like to call Jean Alter.
All right, Madam Clerk.
Yes.
Ms. Alter, if you would go ahead and raise your right hand, and when it's raised, please let me know.
It's raised.
Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay.
Ms. Schmidt?
Yes. Are you Jeff Alter's mom?
I am Jeff Alter's mom.
Okay. Did you give birth to him?
Yes, I did.
Was he born with a birth defect?
He was not born with a birth defect. He was born and diagnosed at birth with a slight heart murmur.
Okay. All right. All right. And to your knowledge, has that changed?
To my knowledge, that has not changed.
Okay. I have nothing further. Thank you.
Ms. Wolfstead?
Certainly. So, ma'am, how old is your son?
Almost 50, I believe. 72.
And
Let's
when was-
see.
48.
48, I guess.
Yeah. So, ma'am, when was the last time you either accompanied your son to the doctor or had personal details of his medical situation?
Not since he was a child.
Okay. And are you aware of a significant drug addiction that your son has?
Yes.
And has that affected his heart negatively, all that you know of or have any medical evidence of in the last 10, 20 years?
I have no medical evidence of that. It's just his constantly telling me that he has heart arrhythmia at night. I have heart arrhythmia. My dad had heart arrhythmia. That's all I know.
Okay. That's all I've got, Judge.
Ms. Schmidt, did you have any follow-up?
No, thank you, Your Honor.
All right, just a moment.
And I guess just to be open with the court, I will let the court know that regardless, the sentencing will not be going forward on February 27th.
Ms. Schmidt, are you offering a third-party custodian for Mr. Alter?
We were going with the ankle monitor, the electronic monitoring, which I think is far better than a third-party custodian.
I wasn't talking exclusive. I was asking if you had a third-party custodian that you could propose.
If the court were to ask for that, we could do ankle monitor and third-party.
Right, and so do you have someone that you would propose?
Yeah, his mother would. She's not done it before.
What I would like to do then is reschedule this for tomorrow. I want to give you time to talk to Ms. Alter about what it means to be a third-party custodian.
We've discussed it at length. The prosecutor would need her information.
Right, I need to give the prosecutor time to do what they need to do in anticipation of it. I'd also like you to go through the court form that she would be required to sign.
Okay.
That outlines what the risks are for failing to abide by third-party custodian duties.
Okay.
Your Honor, if it's possible to schedule it for Monday rather than tomorrow so that we've got enough time to make required victim contact again?
I think I need to let you do that. Just a second.
I'm available on Monday. Ms. Alter, are you available on Monday?
Yes.
Mr. Pulaski?
Yeah, Monday's open for.
How about 10 o'clock?
That works good.
Sure.
That's fine.
All right, we'll take this back up on Monday at 10 o'clock.
All right. Thank you, Your Honor.
Thank you, Mr. Alter. See you on Monday.
All right, thank you.
Our next case is 1JU 2348, State of Alaska versus Patrick Iler.
Let's flip it over that way. See how you talk. That's good.
Time that, Mr. Iler? Okay. Is appearing from Lemon Creek. I should have Mr. Dunmeyer on the phone.
Yes, Judge, I'm here.
And do I have, is it Ms. Kemp?
Yep.
So the first thing I'm going to do, Mr. Iler, is arraign you on a new count that's been added to your complaint in 1JU 2348. It's the state filed an information adding count 5. Count 5 alleges that on or about April 8th, you unlawfully violated your conditions of release. This is a Class A misdemeanor contrary to and in violation of Alaska Statute 1156-757A. It's an A misdemeanor. It exposes you to a 1 year in jail and a $25,000 fine. Specifically, the state's alleging that you were asked to provide a UA, and you failed to do so. After you refused, you went ahead and provided a sample. It tested positive for methamphetamine. So, Mr. Dunmeyer, you had a bail proposal?
I did, Your Honor, but given that he's in custody, I don't think it makes sense to go forward with what I had proposed.
Okay. All right, then. Is there anything else for Mr. Iler?
Bail, Judge.
Actually, bail, yes. Mr. Iler, just a second. Ms. Kemp?
So, my request today, Judge, is to revert bail back to the previous setting. I'm in the process, and we'll get the paperwork out here shortly from the $2,500 that was posted by his mom. As I understood, that was posted on March 23rd. He was released from custody based upon his mom's posting. His mom, for the court's benefit, shares the same residence at Melrose Place and did, prior to the events in this case. Mr. Iler was residing, if not permanently, at least temporarily, at that location in an outbuilding shack. And I won't spend a bunch of time belaboring all the things that we discussed before as far as the underlying circumstances of the case. But the new information that I have related to his EM device and something that I mentioned, I don't know if Ms. Comar's on the line. I kind of assumed they would be, but I guess not. So Mr. Iler has been warned repeatedly, it sounds like, to not unplug his EM device. And I just actually sent over some graph points, some GPS points that show that Mr. Iler's not only obviously been using methamphetamines, but been moving that device around, unplugging it, and the GPS points indicate that he's gone as far as, I think, to Melvin Park. Let me pull up what I have here. Away from the residence, so accessing much further points than I think the court intended when it placed him on house arrest. Let me make sure I'm getting representing correctly what was relayed to me. We'll get to the graph. In any event, Judge, the information that I have from PED is that he's been warned about that because it's affecting the integrity of the system in part. In addition to that, it sounds like when they went to contact him, as the court probably already knows this information. Oh, Ms. Comar is on the line, so she can supplement or correct me if I get any of the facts wrong as far as what she knows. But it sounds like when they went to the residence, they actually found the device in the shed in the and I don't really understand quite exactly what's being described, but in a compartment above the shed, and I would hope that Ms. Comar would help me if I'm misstating something here factually. When they came on the property, they were asked by the defendant's mother, who yelled out the window, to identify themselves. They did. I don't see anything wrong with that. Obviously, she has a right to know who's on the property. And then ultimately, they went into the shack where he was living with Billie Jean Tonsgard, or Billie Jean, I should say, and found and asked. They were asked him where the beacon was. He pointed to a hole in the ceiling of the room. And they could not see the beacon. I don't know if any of this is relevant as far as the integrity. I'm just repeating essentially what was relayed to me. They asked him to do a UA. He initially refused and then ultimately did provide one at the jail that was, as I alluded to, positive for methamphetamines. They did, he initially denied use, but then said he was accidentally given meth a few days prior. Wasn't sure why someone would do that, but he thought they put it in his alcoholic drink. The old mess in the coffee or drink excuse. But in any event, so I'm asking the court to revert bail to what was previously set. As I said, I'm going to petition to the court to forfeit the bail that was previously posted. Obviously, that issue's not ripe, and I expect the defense will want an opportunity to have a hearing. But as the rules provide, I have to get that on paper before the completion of the case. And because I'll forget, I did it, and we'll be filing it here very shortly. But that money is otherwise now, from the state's perspective, encumbered based upon the violation of this condition. So if I've gotten any of that wrong, I would hope that Ms. Comar would either supplant what I've said or correct me. But that's the information that I have, Judge.
And what is the bail that you're asking for? How much?
It was previously set at $25,000. It was reduced by the court on the back to my notes here, on the 23rd, and then later that day he was released into house arrest at that Melrose Street address with EM.
Mr. Dunmeyer?
May I say something?
So, Mr. Iler, this is your attorney. I'm not in a position to make an argument for you today, and I'm not going to make one. My advice to you is to not say anything, because I don't think that you'd really be able to help yourself in this situation.
Well, I was told by Mr.
Iler, wait, one second. Before you talk, I want to remind you, we record these hearings. If you say something that the state feels it can use against you, it will, and it is entitled to do so. You might want to talk to Mr. Dunmeyer before you proceed.
Just a couple things that I don't think I need to talk to him about, if that's all right.
Well, he's advised you to talk to him first, so...
Okay, well, I'd just like to say that the hole in the ceiling they're talking about, there's actually just a little, it's like a 4-foot shelf, that ladder that goes up to it, like a little loft thing that I store things in. The only reason it was moved there was because she had told me there was some kind of reception problem. That's why it was up there. And also that I have people that could testify. I've never gone to Melvin Park. I've never left the property at all. She told me I was going outside too much, and I was going outside and cleaning out an RV on the property and stuff, and I didn't realize that I couldn't go outside for long periods of time. I was not leaving the property whatsoever, and when she told me I couldn't be outside for long periods of time, I don't believe that I have. I went just right up over to my parents' door. Other than that, I've been in right where I should have been. Also, the PD person told me yesterday that I had $1,000 bail on the new complaint, and I have that, and I was trying to have it dropped off earlier, and they wouldn't take it or something.
That's incorrect info.
What is?
That there's $1,000 bail on your new V-Corps.
They said at booking that there was, and yesterday when I was dropped off, And, okay.
So that they're incorrect because they don't understand that it was a count added to your existing felony case and not a new charge. If it had been filed as a new charge, there would have been, it would have fallen under the bail schedule as booking told you, but because it was not filed as a new charge, that's not what happened.
Okay.
This is what, so all of the information that you've given are things that Mr. Dunmeyer needs some time to look at and talk to you about so that he can, if he wants to, put on a request for a bail hearing.
Can I say, I got a lot of, important things going on right now. Kind of, all right, okay. Thank you.
All right. So the same conditions that were set as far as, where Mr. Iler is to reside and the testing conditions and not consuming controlled substances, I'm going to include those on as part of Mr. Iler's conditions of release. And otherwise, I'll just, consider this particular bail request withdrawn and wait to hear from you, Mr. Dunmeyer, if you feel it necessary to do so. All right, is there anything else for Mr. Iler from the state?
Just for clarification, Judge, I think I understand what you did, but so you're reverting the bail back to $25,000?
Correct.
And then the previous conditions as ordered on the 23rd?
Correct. I'm keeping,
okay.
Yes.
Okay, thanks. I just wanted to clarify that. Thank you. Nothing else for me.
All right. Anything else, Mr. Dunmeyer?
No, Your Honor.
All right. Thank you, everyone.
The chairperson has disconnected. The conference will now end.